Yeah. Hello, everyone. Thank you for joining us. We'll be starting in a few minutes. In the meantime, I'll be starting a quick poll so that you can let us know where you're dialing in from, if this is the first Center for Art Law event you're attending, and what is your occupation. Hello, everyone. Thank you for joining us. We'll be starting in a few seconds. In the meantime, please let us know where you're dialing in from and if this is the first Center for Art Law event you're attending using the poll that's currently on the screen. All right, I think we will get started. We'll continue to monitor the waiting room. But in the meantime, thank you for joining us. Hello, hello. My name is Louise Caron. I am the Executive Director here at the Center for Art Law. So I see on the poll that I'm going to share the results with everyone. You can see that most of the people who joined us today are on the East Coast, so good afternoon. We also have some people in Europe, so good evening, I guess. I see that we have a lot of returning attendees and guests. Thank you for joining us and otherwise welcome. And we have a good number of attorneys as well as art market professionals, students. So thank you for joining us. I will stop sharing and I will tell you briefly about this wonderful program. So thank you for joining us in this digital space. Welcome to today's Art Law Lunch Talk about famous fraudsters who duped the art market. Many thanks to our speakers, Eileen Kinsella and Dean Nicyper, whom Irina Tarsis, the center's founder and today's moderator, will introduce in more details shortly. Thank you to our interns, Mary Kessel and David Jenkins, who helped in putting this program and the course materials together. If this is the first time that you're attending the Center for Art Law event, let me say a few words about this wonderful organization. We are a Brooklyn-based and research and education nonprofit dedicating to offering resources and programming for the advancement of a vibrant arts and law community worldwide. Through our website, our newsletter, and events, we disseminate information and keep our audience updated on art law related news, programs, cases, publications, and so much more. Now fully online, as you can expect, the center facilitates conversations by hosting and participating in programs such as today. We also have a great internship program that allows students to get a firsthand education and experience in art and cultural heritage law. So we invite you to subscribe to our newsletter to receive updates and invitations and to visit our website at itsartlaw.org. And if you can, make a donation to support our efforts in making art law accessible. So before we begin, a few of the usual housekeeping items. This program is currently recording for archival purposes. Feel free to turn off your camera and everyone will be muted except for the panelists for the duration of the program. If you wish to have captions on, live transcription is available at the bottom left corner of the toolbar on your screen. Also, if you have any questions, please ask them using the chat box at the bottom of your screen. We'll be monitoring the chat. Sorry? Nope. Okay. We'll be monitoring the chat and sending links to relevant articles and cases throughout the discussion. We'll happily help you with any tech issues or practical questions. And finally, a link to the handouts with bios and reading materials was sent to you earlier today, and I will put it in the chat shortly. They will be emailed to you at the end of the program along with a brief survey, which we'd appreciate that you take, as the result will allow us to bring together more events and speakers of interest to you. Now, without further ado, let me introduce Irina Tarsis, the founder and managing director of the Center for Art Law, who will present the speakers and get the conversation started.
Thank you, Louise. Thank you, everybody, for joining us. It's a wonderful subject that we are about to tackle. I don't invite you to game the art market. We've tried with the auction that just ended, and I think we did okay. We didn't game it, but we didn't lose either. I wanted to say thank you to all who participated as our donors and bidders and supporters. And many, many thanks to our executive director, Louise Caron, who was able to juggle so many different tasks, including wrapping up the auction and taking care of the public programming that we are enjoying. Thank you very, very much. What are we talking about today? You know, we're based in Brooklyn, typically, and there are a couple of bridges around our office. The one up front is not available for sale. It's taken, it's called the Manhattan Bridge, but the one in the background, it's well lit, and if anybody is interested, we can give you the dimensions, we can tell you who built it, and if you are interested in buying it, it's available. And so these sales sometimes take place where dealers are able to tell a good story and convince a lot of lovers of beauty to gamble and risk serious investment, financial, and other kinds of assets. These are just headlines from a few cases and stories that took place in the course of the 20th century. And they read quite fresh, whether they came from 1960s, 80s, 90s, 2000s. A Manhattan art dealer was indicted yesterday on charges that they're usually he's, directed a certain amount of money away from a particular transaction or particular client. So I have collected very briefly a number of names, and you might recognize them or not. Dennis R. Anderson from 1980s, Todd Michael Wolpe, Michael Cohen, David Stein, Davis Ramis, Larry Sounder. I think we're getting closer to the present days. Inigo Philbrick. What do they have in common? They made headlines and they were able to defraud a number of collectors out of their art. I'd like to make sure that when we're talking about fraud today, we're talking about dealers who were accused and maybe pled guilty to wire fraud and maybe tried to sell certain works of art, not fakes, but not works that they owned or that they could sell multiple times to different collectors. We are hoping to speak about forgeries in our future programming 2021. So today we're focusing on the subject of dealers who defrauded certain clients when selling authentic works. With that in mind, I would like, well, if you're not interested in headlines, you can also look at Wikipedia and be surprised why Michael Cohen, for example, not the one associated with the former administration, but an art dealer who swindled millions of dollars, has a very brief bio versus Lawrence Salander, who actually pled guilty and served some time in prison, has a longer tombstone. So we have two guests with us, experts on the subject of the art market and who have talked to and about art fraudsters. These dealers who have been able to tell good stories and get away with a lot of interesting shenanigans until law and reporters caught up with them. Our first guest today is Eileen Kinsella. She is, I'm sure, known to all of you. She is a reporter who covers many, many fascinating art law subjects. And Eileen is going to talk to us about what she does, how she, as a member of the public, um, faces news stories. When news break of another dealer being accused or caught or um, who pleads guilty, what does she do with this information? How does she present it to other lay persons? Eileen, would you take us on your tour?
Yeah, sure. I can go to the first slide. I think with the Okay. Yeah. So, I mean, I'll start by, as you've demonstrated, saying that art fraud is nothing new. And I think what stands out more nowadays is just that the stakes are higher than ever because the market as a whole has soared. I mean, contemporary art in particular. And so definitely the stakes are higher. And we've seen connections with some of the cases that we'll get into today, starting with Cohen and Salander and more recently Inigo Philbrick. And one of the things that we had talked about was how I find out about news or court cases. And in each of these cases, I didn't cover Cohen that extensively, but I covered Salander and Inigo extensively. It always starts out with some kind of this like whisper. And the whisper sort of comes after the person is already well established and has this like great reputation where it's sort of like, hey, did you hear that maybe like they're not paying their bills or some people are complaining about not getting paid on time and things like that. And sometimes that happens and there's nothing after it. But I remember distinctly hearing both of those signs of kind of red flags or trouble with both Inigo and with Larry. And they were very shortly after followed by, you know, there was like one lawsuit and then there was two lawsuits and then there was like a flood of lawsuits. So from a journalistic point of view, those tips, you know, very quickly rolled into something substantial that you can then see in the course of a lawsuit that's brought about how somebody put up 50% of a painting because they thought they were going to, sometimes they did get back their 50% plus a profit on top of it, but then it quickly slowed. And it's not unlike a Ponzi scheme. So the thing that stands out to me is that, you know, maybe if you're the person that's the investor, you're not going to get those whispers, not the way that somebody will kind of come to me or that's just gossip. Maybe if somebody knows that you're the person in business with them, they don't want to send a red flag to you. So in that way, and I'm not saying this sarcastically, it's almost like I would have an advantage because people might feel more free about sharing, you know, concerns or red flags, as they say. You know, one of the things, the commonality there is again, the trust that they had built up with very wealthy clients. They did well for a while, you know, until they didn't. And always in retrospect, it's sort of like, where did the gray area come in? Where did they start getting into trouble where, you know, they couldn't pay people back or they claim they want to, and they just, you know, needed more time. And so, you know, since we are talking about lessons not learned, there are some aspects where we kind of shake our heads and say, you know, why do things keep happening on handshake agreements and people need to wise up. And in some cases they have done. Like I know Salander definitely made people more cautious about documenting ownership and, you know, signed contracts. And then in Inigo's case, there were signed contracts and people really carefully, you know, had like a 70-page document about each work that they owned and what he was supposed to do with it. And they still had major problems where he sold it out from under them. So I wanted to make that point and just also say that even if there are, you know, signed contracts, there have been points, and I will point them out as I go through some of the slides, where there were red flags, where a simple Google search might tell you that a painting that somebody just sold you a half share of for $9 million sold not that long ago for $10 million, which would prompt you to ask, how over the course of 4 years did a painting go from being worth 10 million to 18 million, and who are the buyers for it? So I point that out just as that the art market is very unregulated, but I do think there is an area where if you're spending millions of dollars, you owe it to yourself and your bank account to take that extra step and do that Google. Okay, I'm going to start with Larry Salander, who I reported on extensively, and I can't believe it's already a decade ago. He was a very prestigious dealer, and he dealt first in American art, and then around like the mid 2000s started getting into more historic art because he thought that was going to be good for the bottom line. He rented a palatial gallery on the Upper East Side that I know the rent was very extensive for. And it was probably around 2007, around the first time that lawsuits were filed, that I was hearing he had sold shares of work that he sold them 3 times. He effectively sold 150% of a painting, which obviously you can't do. Or that, he sold works that had just he had said, hey, I'll store something for you at my gallery. And then people found out that they were sold without their consent or even, discussion about it. So by the time the FBI raided his gallery in 2007 and he declared bankruptcy, then he pleaded guilty in 2009 to counts of grand larceny and, pled guilty in court. And, he defrauded very high profile clients like John McEnroe and Robert De Niro, and his fraud was estimated at upwards of 120 million. Well, I learned a lot about bankruptcy law when I was covering that case, because it was really educational to me to find out who had priority on, a painting that you invested 5 million in, thinking that you now own half a share, and to find out, this hierarchy of like, who would get their money back first. And I know the bankruptcy trustee was trying to work all of that out, but I mean, it was really, it was a mess in terms of what had been consigned, what, had been stored with him, and what assets that he owned that needed to be sold back. Sold for money so that assets could be relocated to the victims. So even though, he pled guilty and he got 6 years in federal prison in 2010 on those 29 plus 1 counts, this article dates from 2014, we were still reporting in 2016 about efforts to get money back. I know Robert De Niro, whose father was an artist, a very well-respected artist, at one point paid something like $14,000 to retrieve his father's works. Just to say that the treatment was very different, and I know it was being worked out by the courts, but it was very unpredictable as far as how things would go. Even after the whole criminal plea took place, and he did get out at the end of 2016. I haven't heard anything about him, but yeah, a lot of people lost a lot of money, were victimized, and again, I say that to point out how complicated it is when there's fraud like this. So next, the more recent person that I want to talk to, who I've been reporting a lot on, is Inigo Philbrick. He's very young as far as art world people go. I had been hearing his name around a lot. He had a very auspicious start in the art world. He grew up in Connecticut. His mother was an artist who, as I understand it, took him to openings and, art events throughout all of his life. He was very immersed in it. And his father was an art director at a museum in Connecticut first, then at a museum in Philadelphia. He was known for his networking and his fundraising skills. He did a great job with the Aldrich Museum of Art. Inigo went on to attend college at Goldsmiths in London, very prestigious college of art, and then got an internship at White Cube, which you may have heard of. It's one of the biggest galleries in the world. They're famous for having jump-started the careers of the so-called, YBAs, the young British artists, including Damien Hirst, Tracy Emin, many others associated with that movement. And so, what a great place to land in your immediately out of college. And from what I've told, he thrived there. He had a great knowledge of the market. He really understood the ins and outs of particular artists and was all about the deal. He was all about finding out who owned what work was where, possibly finding a buyer for it. And even then, maybe his ambition and his aggressiveness was starting to get people a little cautious. Or maybe that's hindsight, but certain people that, knew his time at the gallery told me that, doing deals all the time. Then it wasn't long before he started managing the gallery's secondary art market business called Modern Collections in London. Big responsibility for a 20-something year-old person just out of college, but apparently did very well, was very busy. That's when his profile as a major deal maker really started to rise. Next step is that he goes out on his own with a gallery in London. He has some backing from White Cube, which I'm sure helped him out a lot. Again, deal making for years and years. At the end of 2018, he opens up another gallery in Miami. And I think that was around the end of 2018. I think that was when the cracks started to show, where people were starting to maybe not get paid as quickly as they wanted to. He started getting some aggressive emails from a pair of German investors that he had this flipping deal with. In retrospect, I've gone through those emails and looked at like the correspondence and sort of the rising tension of that. To give you one idea of a deal that happened, while all this was going on, and you can see the tension mounting, is that a painting by Jean-Michel Basquiat, one of the most expensive artists in the world, who sold for over 100 million at auction, was sorry, let me get to this slide. So this is it here. It's Jean-Michel Basquiat, Humidity. And you can see this is a public auction record. It sold at Phillips in 2012 for just over $10 million. It's below the estimate. This was a painting that at some point Inigo got his hands on. I'm not sure exactly when and how, but he went to his good friend Sasha Pesco, who runs an offshore company called Sat Finance, and he said, "Hey, this painting is a great investment opportunity. It's worth 18 million. I plan to flip it. If you give me 9 million, I will flip it. I'll get a better price for it, and you'll get your initial investment back, and we'll share the profits." And so it took some convincing, but he got Sasha to invest in it, gave him 9 million plus a share of what Inigo was supposed to put up for his half share of it. And this is a point where I'm saying that a red flag could have been seen. All that Sasha had to do was Google this painting and see that it sold at Phillips 4 years before he was approached with an investment opportunity. And it might have prompted you to say, why is it now worth 18 million? And it goes a step beyond that, which is that Inigo told him, Phillips was never even mentioned in the deal. Inigo drew up paperwork to say that he got it at a company in Pennsylvania called SKH Management, which doesn't exist, and that he bought it for, I think, 12.6 million. And so, Sasha just bought that story. And so after he gives over 9 million, he's under the impression that he now has title, that the work is his because he's given over the majority of the money. Unbeknownst to him, Inigo then turns around, transfers the ownership title of the work to himself with an offshore company, and then uses it as collateral for a loan. He was already, his debts were mounting and he needed money. So he used it as collateral for a loan. Then, the first lawsuit comes out as all this is happening. And after the first lawsuit came out, which was fall of 2019, it opened the floodgates. Anybody who saw what was happening with this company that was now out $14 million, and I think it was 8 or 9 artworks. How could alarm bells not go off if you're in business with this gentleman and seeing what's been going on behind the scenes? That opened up the floodgates for a number of other lawsuits that showed, really serious wrongdoing with, again, selling shares of works that were either misrepresented as far as ownership, overselling what they were worth, and then, using them as collateral for loans, work that doesn't belong to you, and obtaining millions of dollars in loans. And then one final point to that, Inigo convinced Sasha that it was going to be a great thing for marketing to send this painting to Tokyo, to the Mori Art Museum that was having a big Basquiat exhibition. It's not a lie to say that including a painting like this in a big exhibition is a great idea because it's great exposure. Then you have it documented in the provenance, that's where it was shown. All of these things might enhance the appeal for a buyer. And Sasha did so. Unbeknownst to him, when the floodgates opened and everybody was scrambling for assets, the lender, which had paperwork saying, we've loaned millions against this work, it's ours, went straight to the museum in Japan and nabbed it. They got a hold of it. They proved that they owned it. And it was taken back to New York. And now they're still fighting in court over who has the rights to this. That to me is a very similar reflection to Salander, because it's sort of people thought they were doing the right thing. They thought they were documenting their ownership, and now it's caught up in the courts, and courts will decide who has priority. It'll be interesting to see what happens there. That fight is still very much going on. After covering that lawsuit, then I did a comprehensive story that really looked back at his years of business. In a year when he recorded something like $100 million worth of sales, the profit was a very slim 1 million. And then the next year when the intake was even higher, there was a $900,000 loss, and they chalked it up to currency losses. None of that really makes sense. I mean, that would definitely be a red flag. And some of those numbers are available at the UK has a Companies House, where companies are required to record their income and their profit and loss. I think the Basquiat is a really good example of what happened, because that happened many times over. And if anybody needs specifics, I'm happy to provide links to that. And so lastly, he fled Miami, fled New York when the first lawsuit hit. He never answered it. And he was dropped by his attorney shortly after. He was missing for 8 months. There was tons of speculation about where he was. Was he in the South Pacific? Was he in the Bahamas? Was he in Japan? And so after 8 months, I started hearing that the Department of Justice was investigating. Of course, they would not confirm that, but people that did business with him told me that they had received subpoenas for copies of their records, which obviously would show, what he did when, what date, and what might, be criminal behavior. So I'll wrap this up now by telling you that he is still in custody in New York. Despite whatever happens with the criminal charges against him, I think it's going to be a long road ahead for people to retrieve their money, people who have been defrauded. And in one recent bail hearing where he was denied bail, the judge considers him a flight risk. The U.S. attorney said that there would be evidence production of some 10,000 emails documenting his business. And I think that's going to give us even more insight into what he did, how he did it, who else might have been involved. I thought it was very funny that the judge in the case said, 10,000 emails, how many bread boxes are we looking at? And the US attorney said, that's a lot of bread boxes. So I'll leave it there. I will turn it over to Dean, and thanks very much for listening.
Thank you very much. Before we hear from Dean, a couple of questions. So how do you choose the stories? Do you wait for a story to come to you, or are stories assigned? Do you
No, I mean, well, with certain cases like this, it's become so sprawling that there are developments on any given day that, maybe if I'm not there, another reporter will take. But I have just sort of gravitated to it over the course of all the years that I've been reporting. I'm always intrigued when I read a lawsuit that tells an astonishing tale, and from then it's usually kind of a web where it branches out, and it's like, here's this person's attempt to stop what that other person is doing, and who has priority and who doesn't. I've learned a lot along the way. And as I mentioned with the Salander bankruptcy, even though a lot of it was off the record, I found that it was very helpful to talk to attorneys who didn't want to go on the record, but wanted to make sure that I had an understanding of how bankruptcy law works and what their clients were trying to do. And that to me was also very helpful for even today reporting, where, I'll call an attorney who's representing a client and they may not want to go on the record, but they'll tell me things that, of course, I have to take it with a grain of salt. This is litigation and people have a case, but you learn a lot by getting some background, or like, here's what wasn't in the lawsuit. Here's what we couldn't say, but we might get into later.
And do you get to interview, did you interview Larry, or is that part of the work that you do?
If they want to talk, I always give people the opportunity to comment. In all of the years that I covered Larry Salander, he never spoke to me, never answered any of my emails. And by the time he was already pleading guilty and going off to prison, his attorney had advised him not to give any interviews. But it's surprising sometimes who will talk and who will not. Sometimes people, feel they have a side of the story to tell. And I have to give somebody the opportunity to comment, but I'm always curious to hear the other side.
So Inigo Philbrick is deemed and has demonstrated his flight abilities. Another dealer who was a flight risk and never pled guilty was Michael Cohen. There is an interesting, I think, documentary where he is interviewed, and I think we'll share with you access to that documentary. Our second guest, Dean Nicyper, he is a partner at Withers law firm. He has worked on at least 3 or 4 of these named cases, or has firsthand experience trying to untangle some of the messes that these art dealers have left behind. So we look at the range of damages and punishments and kind of side effects. Michael Cohen fled and for now, forever has escaped any kind of punishment. So hopefully, Dean, you'll talk about it. And then we have some dealers who have pled guilty and did serve time and left prison and probably left the art market's spotlights. So Dean, do you mind talking to us about this fraudulent behavior that we see over and over again, and help us look at the same content from the legal point of view?
Yes, absolutely. So thank you, Irina. As Irina mentioned, I'm the head of the litigation team at Withers Bergman in the US. We have offices around the world. So we practice in New York and London and LA and Milan and San Francisco and Hong Kong with our art law team, with doing both transactional and litigation. And I want to thank everyone for joining this program. And I particularly want to thank Irina and Louise for putting this program together, and really for all of the tremendous work that they do at the Center for Art Law. So as Irina mentioned, and Eileen gave a terrific presentation about this, really we're talking today about the largest art frauds of this century. And there are three that I can cover specifically and would like to focus on because of my direct knowledge with them, in that I represented victims in all three. And they're Michael Cohen, but he liked, once he came to the US, to call himself Michelle Cohen, Larry Salander and Salander O'Reilly Galleries, and Inigo Philbrick. And while all three of these scandals have unique facts, they also have striking parallels in my view. And I'll cover the facts of each very briefly, although Eileen really went through some of it. So I'll try not to duplicate if I can. So let's first deal with Michel Cohen. Michel was an art dealer. He developed a good reputation among major art dealers over a 17-year period. In 1987, he opened his first gallery, named it Pentimento, and he became particularly well known for dealing in Picassos, and Chagall's. He was known by and did deals with all of the major art dealers handling Impressionist and modern art. He became very successful, and by the late 1990s, he had an art dealership in both Malibu and New York. In the year 2000, my client was Sotheby's Financial Services, and they had made loans to him using art as collateral. Cohen had a good relationship with Sotheby's for several years. He had a revolving loan, as many galleries have. And after several years of successful dealings with the revolving loan, Cohen proposed a new type of transaction. And that was, he would go to Sotheby's and tell Sotheby's, listen, I can buy a painting and I already have a buyer for it. And if Sotheby's, if you finance this painting, I will then buy it, sell it, and we can split the proceeds 50-50. They called these venture deals. And Cohen proposed, they did one venture deal, and it was very successful. And then he proposed 4 more venture deals, 2 involving Picassos, 2 involving Chagall's. And with his revolving loan and these 4 open venture deals, Cohen was indebted to Sotheby's to the tune of about $10 million. He, in 2000, failed to make payments by the fall of 2000. He kept promising payments coming. I just haven't been paid yet, but you will be paid. And then he bounced 2 checks for several $1 million. At that time, we realized this was necessary to bring a lawsuit, and we did so. So in January 2001, we sued Cohen, alleging fraud. We sued him simultaneously in Malibu and New York City. And as soon as we filed the lawsuit, the press picked it up, and Forbes had an online article about it the same day. And within 1 week, another dealer filed a lawsuit against Cohen, and within a few days, victims' losses were reported to have climbed to $40 million, and the total losses when the dust settled were estimated to be about 50 million to 100 million. And this is back in 2000, 2001. In our lawsuit, we also obtained a court order requiring Cohen to appear for a deposition. And on the court-ordered deposition date, we were in our conference room with Cohen's lawyers, waiting for Cohen to arrive. And 30 minutes passed, no Cohen. Finally, 45 minutes later, his lawyer received a call from Cohen who said he was unable to make it to this deposition. Well, this was a court-ordered deposition. It was not optional for him. So at that point, it was apparent he had fled the US, and that was the last anyone had seen of him for years. The FBI and Interpol chased him, and more than 2 years later, in May 2003, he was finally arrested in Brazil. The US was unable, however, to extradite him because of a law in Brazil. And he managed to escape from custody in Brazil. He was being transported in a car. He hopped out of the car, and he has not been arrested since. However, as Irina pointed out, there has been a documentary created about him just last year, and the BBC produced it, and they did interviews with him, and he's in France. The documentary focuses on Cohen's contention that he had lost all of his money in commodities, futures, options trading. And there's no question he was involved in that. And, there are people who say he had a gambling addiction with this. But he also retained some money, because the documentary never explains how Cohen afforded an expensive home and chauffeur in Brazil for a couple of years, how he afforded a plane ticket to France when he fled across the Brazilian-French Guiana border, and how he paid for himself and survived over the last 17 years in France. During our lawsuit against him, I obtained his bank and brokerage records, and I had tracked 27 million going to a Swiss bank account. What he did with that, I don't know. Interestingly, I may have mentioned Cohen's initial business name, and he used it throughout, was the word pentimento. As many of you probably know from experience in the art world, that describes a situation in which an underpainting starts to show through to the surface after many years. So what are some of these examples of fraud engaged in Michel Cohen? Well, he would sell a painting to two or three people, take their money and not deliver the painting, except maybe to one of them. Cohen sold paintings to people who immediately consigned them back to Cohen. He took possession, sold them, and then never paid. Cohen entered in the loan deals I talked about with Sotheby's, under which Sotheby's invested money to buy a painting, and he'd resell the painting. But he would take the money. He often sold the paintings to more than one buyer, but he never paid Sotheby's. News reports about Cohen at this time were drawing the conclusion that, and I'll quote, "The days of art deals on a handshake are over." Well, as we know in retrospect, memories are short. So a few years later, the Salinger O'Reilly Gallery's scandal surfaced. Here are some facts. Eileen mentioned a few. Larry Salinger opened a gallery in New York in 1974. In the 1990s, the gallery moved to an impressive space on 79th Street. And then in 2005, the gallery moved to an even more impressive location on 71st between Madison and 5th. It had 6 floors, 25,000 square feet, 4 separate floors of gallery space. By 2005, the gallery had created the appearance that it was one of the most financially successful galleries in the world. Behind the scenes, however, it was deeply in debt. When the gallery moved to its extravagant location in 2005, its debt problem became very serious. First Republic Bank pumped tens of millions of dollars into the gallery to keep it afloat, and took a security interest in the inventory the gallery held. Earl Davis was the son of a well-known American painter, Stuart Davis. He had a 20-year business relationship with the gallery. He had consigned hundreds of his father's paintings and drawings to the gallery. And in 2004 and 5, he had stopped getting reports about the consigned work. And he asked the gallery several times what happened about the work, and they dragged their feet in responding. Finally, in 2007, an administrative person at the gallery revealed to him in early 2007 that almost 100 of the most valuable works that his father had created were missing. He discovered that the gallery sold approximately 75 of them over the preceding 10-year period without telling him and without paying him any of the $10 million in sales proceeds that the gallery received. And in fact, the amount of the value of those works was really 30 million because the gallery sold them at fire sale prices. So in May 2007, Earl Davis filed a lawsuit. He had us file a lawsuit against Salander. We obtained an injunction requiring the gallery to return works of art that were still in the gallery's possession. We were able to retrieve about 15 works, 75 had been sold and 10 were missing. After we sued the gallery, again, other consignors and creditors began to file lawsuits against the gallery. By September 2007, new lawsuits were being filed nearly every day. In October 2007, a company named RAI filed a lawsuit. RAI had entered into a joint venture with the gallery in the spring of 2006. The joint venture was to purchase Italian Renaissance works of art. And in mid-2007, RAI discovered that the gallery had been selling some of the joint venture's art without disclosing those sales or paying RAI. On October 9, 2007, RAI went to court and obtained a restraining order against the gallery and preventing it from transferring any more of the joint venture's works of art. 2 days later, more joint venture art was removed from the gallery. So RAI went back to court, obtained a second restraining order, and obtained a court order to get the gallery padlocked to prevent Larry Salander and other gallery employees from entering the gallery. It was a huge scene. News reporters were there. And in this photo, you can see Larry Salander on the right with his wife in the back, and they're both holding their son while the gallery is being padlocked. At the next court hearing in RAI's lawsuit, you could barely find room in the courtroom to stand. It was packed with dozens of lawyers representing dozens of claimants. And then came the bankruptcy for Salander, and 18 months later, the Manhattan District Attorney indicted and arrested the gallery and Larry Salander. Salander, as Eileen mentioned, ultimately pled guilty and served a 6-year jail term. So what are some of the examples of Salander's frauds and thefts? He took art on consignment, sold it, and kept 100% of the proceeds. He entered into a joint venture with RAI, which invested millions in Italian Renaissance arts purchases, but Salander secretly sold the art and kept the proceeds. And on individual painting purchasers, he entered into joint ventures with investors such as John McEnroe. And Eileen mentioned there were John McEnroe, Robert De Niro was also another celebrity who dealt with Salander. And then those, Salander sold participatory interest, selling 150% interest in work, secretly selling the paintings to others, and then keeping the proceeds. And as Eileen mentioned, the bankruptcy went on for years. The bottom line is no victims ever recovered any money in the bankruptcy. Only the bank obtained recovery. The victims were left to fight among themselves, and many lawsuits among the victims followed. The Salander scandal received an enormous amount of publicity. But again, memories are short, and within several years, the next similar fraud purchased. And of course, I'm talking about Inigo Philbrick. It was now his turn to step up to the plate.
Dean, I wonder if we can look at the time tables for Inigo a little bit quicker, because Eileen has covered that story.
Yeah, absolutely. So I'll do those, and that's a good point, because I'll just point out a couple of facts. In 2010 is when he started at White Cube. He was 23 years old at the time. And within only 3 years, in 2003, he had moved up the ladder and then opened his own gallery in London. And it was in 2015, when he was 27 years old, that he signed that first deal with Fine Art Partners in Germany, selling them a Rudolf Stengel painting. And as Eileen pointed out, he was supposed to resell that painting at Christie's for $9 million guarantee. He instead sold it to another investment firm for $6 million, who sold it at Christie's for a published sale price of $6.5 million. And of course, this took a couple of years for all of this to take place. And FAP saw that and asked, well, what happened to our $9 million guarantee? And he had a hard time explaining that, and things started to fall apart. Philbrick, in fact, signed many deals with FAP for concerning many works of art. In essence, FAP was really financing many of his transactions. You know, repeats what we've heard about with Cohen and with Salander, going to the banks, going to financiers. FAP's agreements with Philbrick enabled Philbrick to retain possession and gave Philbrick the authority to resell the art. I thought it was interesting that, I'm not sure which quote you have here, but in 2016, in a podcast, Philbrick said, "For me, the ideal thing is that you have trust with the person you are talking to. And because you have this great relationship, it saves me the work of having a great relationship with a person that you already have a great relationship with." Now, take that to mean whatever you would like, but it does demonstrate the importance that all of these people we're talking about today had established a huge relationship of trust with the people they dealt with and people in the community. So if you could go to slide 29, a couple of months after Philbrick made that statement, he obtained investments from SAT Finance regarding the Basquiat humidity, telling SAT Finance he was buying humidity for $18.4 million and that he would give SAT Finance 2/3 ownership for its $12.2 million investment. But simultaneously, he took the same painting and obtained an additional investment from another gallery, telling that gallery that he was actually paying $22 million for the painting and that they could get a 12.5% interest. Philbrick forged, as Eileen mentioned, a contract showing SAT Finance a sale price of $18.4 million. And he showed a different forged contract to the other gallery, showing that the sale price that he paid was $22 million. A year later, in 2017, Philbrick pledged the same painting to Athena Art, as Eileen mentioned, as part of the collateral for the $14 million loan. So you can see that he used the trust that he had gained that was so important to his own advantage. You know, as we pointed out, in October 19, Fine Art Partners sued Philbrick in Florida. Word got out. Philbrick fled from the US. SAT Finance sued Philbrick in London. Athena sued Philbrick in New York. And Philbrick was arrested in Vanuatu, and he was actually extradited and brought to the US. So what are some of the parallels that we've seen? Let's first look at Cohen and Philbrick. Both were smart, both were quick learners, both were street savvy and learned the art business quickly. Both gained the trust of major players in the art world through engaging in legitimate business for years, and both ended up defrauding customers by getting people to give them money without having to deliver possession of the art. Critical. Both sold a given work of art to more than one person and kept the proceeds from all sales. Both got people to invest in fractional interests in works of art. Cohen did some handshake deals, but had written agreements with Sotheby's. Philbrick did use some documentation, although much of it was forged. Both Cohen and Philbrick kept their frauds alive by continually promising payment, and the payment was just about to come in. Both fled the country. Both were arrested abroad, although Philbrick, unlike Cohen, was extradited to the US. So let's look also at the parallels with Salander. Salander was also a successful dealer and had gained the reputation of being such, like Cohen and Philbrick, over many years. Somewhat like Cohen, Salander convinced people to trust him with consignments, although the Salanders were long-term consignments. He then sold the art, kept the money, and did not disclose to the consigners that he had sold the art. Cohen did the same. Like Cohen and Philbrick, Salander also convinced investors to invest in him and or loan him money. And like Cohen and Philbrick, Salander also arranged for others to participate in fractional ownership deals. With Salander, it was John McEnroe, but Philbrick got various people to do it, and Cohen did the same. Unlike Cohen and Philbrick, Salander faced the charges, pled guilty, and served time in prison. What are the lessons? You know, it's tough, but you can see a lot of parallels. Most important, as Eileen pointed out, do your due diligence. And when you see red flags, follow them up. Don't accept documentation at face value. as we've seen, Philbrick engaged in forgery of documents, forged agreements with the people he was dealing with. Be particularly diligent when you invest in fractional ownership interest deals, paper them, but most remember possession of art is king. Take possession whenever possible. If you can't take possession, make sure you have unfettered access to that art and be vigilant in checking on it regularly. So those are some lessons. We can see the parallels. I think in large part, due diligence is extremely important. But thank you all. That really is my initial presentation, but I'd be happy to answer any questions.
Irina, you're muted.
There we are. All right, thank you. Thank you very much. So fraud comes in different guises, I suppose, but basically, if we just describe it briefly, is it's a deception to get enriched at somebody else's expense, right? And either you can make a forgery and try to dupe people this way, or you can figure out how to maybe sell something multiple times, or take somebody else's property and sell it, present it as your own. I know that after Salinger O'Reilly disaster, a few changes were made in New York law, for example, encouraging, well, the collectors are always encouraged to file UCC statements, right, to indicate to the world that they do have ownership interest. And artists have received more support from New York law in terms of consigning their works. Do you want to say a few words about that?
Sure. Let me first address the UCC issue because it is an important one. It actually came up in the Cohen cases because the issue was people could have protected their interests with Cohen had they filed UCC ones. If people don't know what that is, I'll explain very briefly. Those are what are called financing statements, and you file them actually with the state governments, the Secretary of State. And what it does is it gives notice to the world that you, in fact, have an interest in that work of art. So after Cohen, it's very interesting when the Salinger scandal hit. There was one particular person who did extensive deals with Salinger, a guy named Joe Carroll. He did file UCC ones, thinking they would protect him. Unfortunately, he was sued in some of the cases that Eileen mentioned regarding John McEnroe sued Salinger. Earl Davis sued Joe Carroll. Earl Davis also sued him because although he had filed UCC ones, he could not represent successfully that he was a good faith purchaser of the art because in fact there were red flags that he either knew or should have known Salinger was engaging in shady deals regarding the consignments he had. And so Carroll lost 2 of the 3 cases that he had engaged in, even though he had filed UCC ones. But also, yeah, after the Salinger case, many of the consigners to Salinger were artists, many, and artists really lost out there. So one of the issues is there's a section, Article 12 of the Arts and Cultural Affairs Law in New York that says when artists consign art to a gallery, that art is trust property held solely for the benefit of the artist. And likewise, when the gallery sells that art, the proceeds are trust funds held solely for the benefit of the artist. The problem is Salinger took the art, sold the art, kept the money. And the statute had no teeth. So after that statute, after that case, the Art Law Committee in the New York City Bar got together. I chaired a committee and we put together some new legislation that put some new teeth in Article 12 so that artists can bring private rights of action, they can recover their attorney's fees, and it also establishes that there is criminal liability for breaching those fiduciary obligations to consigners.
One of the questions we received from the audience is whether the anti-money laundering regulations may assist with prevention of fraud.
Great question. And obviously that's yet to be determined, but I think Eileen will agree to me. One of the problems and one of the reasons fraud can be so pervasive in the art world is the opaqueness of all art transactions. People don't know what's going on. People don't know who's on the other side of a transaction. The anti-money laundering laws currently in Europe and in London, in the UK, and to some extent here in the US, at least with respect to antiquities, and I anticipate that US Congress will probably apply them to all art, will require a lot more know your customer information and a lot more disclosure in order to prevent any money laundering, but it also could very much help with respect to fraud. You know, they will be very onerous, particularly for smaller galleries to have to comply. So there's going to be a trade-off between, you know, the burden that it imposes, but also the amount that it might help in uncovering or preventing potential fraud.
Eileen, a question maybe first to you. Do you feel that with the size of the art market and with the number of dealers that are active in the United States, even if you just look at New York alone, we don't have that many fraudsters, actually. These stories are very rare if you look at the statistics.
Yeah, I'm sort of two minds. Like relatively, yeah, they're rare. I just think that it goes back to what Dean says about the opaqueness of the market, is that you don't always know who's on the other end of a transaction. So sometimes, I mean, I've talked to people sometimes on opposite ends of deals who didn't realize that there was, you know, two intermediaries between them and like the person they even got close to the seller. Like there's no documentation of the chain of, you know, agents who are getting a cut of the deal or who gets promised what. So it's a complicated business. On the whole, I would say that it must have to be not full of fraudsters, because we'd never have an art fair or an auction or the, you know, hundreds, thousands of galleries in Manhattan that we have. But the bottom line is that when somebody really wants to defraud a client, they're gonna find a way, as Cohen, Salander, and Inigo did dozens of times, you know? So yeah, there's bad players, and you have to do your due diligence in order to try to spot them.
It's curious to me that the stories, the biographies that we're looking at, there's certainly overlaps, but some galleries lasted much longer. For example, Salander Riley's gallery was in business for 30 years, right? Until bad financial decisions or maybe the lifestyle and other circumstances caught up. But do you think the life cycle of these, building reputation, coming up with a scheme, defrauding business partners, and then getting caught, are these cycles getting shorter, or there's no rule of thumb?
I think speed and expectation has a lot to do with it. I mean, it's not unheard of that people, you know, hold on to a work and it appreciates in value, and now the market for this person is going up and you want to cash in. In Inigo's case, it was impossible to, you know, he would buy a Donald Judd for you know, 1.2 million and promise these German investors, I'll get 1.8 million. That's $600,000. And there was not a firmly established timeline. Maybe over 10 years, that's easy to do, you know, like, or not easy to do, but plausible. How can you think that like you can just bet that the market for Rudolf Stingel is going to keep going up and up and up? I mean, that painting that he guaranteed the $9 million on, A, the guarantee was false, and B, he's writing to these people saying, oh, this market is so hot right now because there's a show at the Byler in Switzerland that we might even get $15 million for it. How can you possibly predict that? And how can that keep happening over and over again, where an artist just keeps hitting successive highs? There's got to be a cooling off point. That kind of money doesn't flow in 3 or 5 or 7 years, whatever he was, you know, promising. I think that was a key part of the whole point about the implied value and the escalation in value.
So is the lesson to be learned? It doesn't sound like it's a legal lesson, but the lesson to be learned is when something is too good to be true, or your wishful thinking does not necessarily produce lawful or sustainable results, right? Because everybody seems to be happy to engage in investment and quick flipping. And you described the Sotheby's arrangements of these interesting loans and ventures, and they're all financial transactions designed to get quick financial returns,
Yeah.
right?
I think the speculative element is like what you're saying, yeah, too good to be true. Because when I went to one of the art dealers who was initially thrilled that Inigo was coming to Miami, I said, you know, and she's a great, you know, very well-respected advisor. I said, does this make you cautious for your clients? And she said, no, because I don't ever buy 50% of a painting. When I buy a painting for a client, we hang it on the wall. And even then, as Dean and I have illustrated, there are some risks if you're in business with a bad faith buyer. But I think anybody who tells you, you know, this $10 million painting is now worth 18 or 22 million, like, well, why? And how many buyers do you have lined up, and who are they? And maybe it's limited what they can tell you, but there's an element of, yeah, that fantastic deal that you don't have to do anything. You don't have to touch the art or see the art. You're just going to expect a $9 million return is insane in any business realm.
We have a few questions about blockchain technology, whether it can help with contracts such as the ones I suppose Philbrick was entering. Dean, do you have any experience with these smart contracts, and do you think they would be helpful?
They are emerging. I don't have direct experience with any case that has dealt with them. I am aware generally of the technology capabilities. So what it can do is keep a record of provenance and keep a record of sales. Only the person who actually buys the painting gets access to that information, and the information gets input. It is conceivable that it could be of value here. I think we'll just have to see how it plays out.
Any more questions from the audience? I know that at 7 o'clock I have received a promise from our guests that they are happy to stay and answer questions for another 10 or so minutes. So if you have questions, please put them into the chat. One of the questions is about psychology. So, and again, I think psychology does play a role both in reporting on events and in building a case. Do you want to, both of you, say anything about the psychology of these criminals that you have?
Well, I could, yeah, let me jump in with a couple of things. One can argue, and many of the people, if you look at the documentary, a lot of the people who were interviewed regarding Michelle Cohen will say that he was a legitimate dealer. What happened was he was involved in these commodities futures options. He got behind. He had to make margin calls, and that's what caused him to flip and start to defraud people. There is some evidence of that. But as I say, I think also at the same time, he managed to squirrel away enough money to keep himself living well before he fled the country. So I'm not sure he started out in the art business thinking that he would engage in fraud. I think there may be things that got behind. I think with all of these people, Salander actually the same way. I think Salander always argued, you know, I was always going to pay him back. I was going to pay back that money. And what happens is the lifestyle and the robbing Peter to pay Paul starts to get ahead of them so that they can't catch up. I don't know that any of them went into this premeditated, although one could argue the Philbrick things were long-term and appear to be thought out in advance. So the jury's still out on that one as to what motivated him and what happened there. I know the reports are in the news that he had an extravagant lifestyle, but we're talking about a lot of money here. So.
And Irina, if I could just jump in here, you know, I mentioned this in our call last week. One thing that stands out to me is that if the markets for the various artists and the works that he was selling had kept going up, and if he was somehow able to produce this insane amount of money that he needed to pay people back, he would have been fine, because if you got your money, you wouldn't care who bought the painting. You wouldn't even be looking at, like, I don't have the title anymore, somebody else has it. I made out great on this painting. So it's sort of like all these things that he was moving around. If he just had enough cash to pay people off, and I'm not saying that as an excuse to him, I'm talking about the insanity of expecting these kind of returns, and you don't care about the art and you don't want to own it. nobody would have known any better. I mean, Dean, would you agree with that? Like if you didn't care about who owned it?
Yeah, absolutely. I mean, to some extent, it's always getting out in front of yourself and trying to catch up. And that may be true with all three of these.
Yeah.
Dean, there's a specific question on tracing assets abroad. Do you, the answer is probably it depends, but do you think it's easier to bring, or it makes sense to bring proceedings in other jurisdictions where you're trying to locate these assets, or just work with the US to enforce US judgments abroad? So you said there's a case in London, there's a case in US. What kind of thinking would go into enforcement of judgments?
So when you get a judgment, you try to enforce it wherever the assets are. If you can, you'd like to bring the lawsuit initially in the jurisdiction where assets already exist. It makes it a lot easier. You just take that judgment and you enforce it against the assets. If you get a US judgment, it's easier, obviously, to force it within the state, but also next easiest level is to enforce it in other states in the United States. You can enforce them abroad. The difficulty is particularly with default judgments. For example, in the Michelle Cohen case, Sotheby's obtained a default judgment against him because although he initially appeared in the case, he then disappeared. If we were to try to enforce that abroad, I've done this in other cases, not Michelle Cohen cases, it's difficult to enforce default judgments abroad. Courts will often in other countries will enforce US judgments on the merits, but it's much more difficult to enforce default judgments. So that becomes problematic.
Any other questions to our guests? I know that we are sending our reading list and the slides later on. If there are no other, well, and you're of course encouraged and invited, I hope, to write both to Eileen and to Dean with follow-ups or maybe tips for the stories to come. But I wanted to thank all of our guests and all of the Center for Art Law team members who have helped build this program. And many, many thanks to all of you for participating, joining in, for donating to the center to make this program and other programs possible. We are speaking about third-party compensation later this month, exactly to figure out what are the parameters to make things more transparent in the art market. We are looking at the anti-money laundering changes, initiatives that dealers will have to internalize, and hopefully there will be fewer headlines about art dealers being indicted and put in jail for fraudulent behavior. There are thousands of dealers out there, and I do think that we are looking at very, very rarefied bad apple scenario, but many lessons to learn and internalize. Thank you so much, and see you soon, hopefully.
Thanks, everybody.
Thank you. Thank you. Don't forget to subscribe to the newsletter, and we'll also have another follow-up event about more specifically to forgeries. So keep an eye out for our announcements and newsletter. It should hopefully later this spring. And we will send you slides and the survey and the recording as well. So thank you for joining us. Have a great rest of the day.
Bye, everyone.
Thank
Bye.
you.